Is this the end of the personal injury profession? Is there a smoking gun showing these lawyers took advantage? How bad can this get for personal injury lawyers? Uber alleges in public filings all of the following. Fraudulent personal injury claims arising from minor motor vehicle collisions are an urgent and growing problem in California. This fraud results in widespread harm to the public far beyond those involved in the litigations themselves by increasing insurance rates and transportation costs. In the case of Uber, this fraud increases the expense of the many thousands who rely on the Uber application as a means of transportation and reduces the earnings of the many others who earn a livelihood from the application. In Los Angeles County specifically, approximately 45% of the fare of every Uber ride goes to mandated insurance costs, driving up prices for riders and pushing down earnings for drivers. Unscrupulous personal injury attorneys and corrupt medical providers in the Los Angeles area are engaged in this fraud scheme. The lawyers direct claimants to pre-selected medical providers to receive procedures for minor or non-existent injuries, following unnecessary or causally unrelated treatment. Certain providers generate and submit artificially inflated bills for such treatment. These bills are issued on a lien basis, rather than using claimants' own medical insurance for treatment. The claimants instead enter into lien agreements with the medical providers, which grant such providers a lien on recoveries from the claim, and purport to promise full payment to the medical providers in the event of a shortfall in recovery. Such arrangements are in reality, the claimant's lawyers and certain medical providers secretly enter into side agreements under which the medical providers agree to substantially discount their bills in the event that the recovery is insufficient to pay the artificially inflated medical bills because the side agreements are concealed. The medical bills are false and misleading. The bills are then utilized as the basis for a false and artificially inflated damages claim. The secret side agreement functions as a kickback. In exchange for a steady supply of claimants from the lawyers, certain medical providers agree to surrender their lien rights. The lawyers profit because they receive priority recovery of their fees and other costs. The medical providers profit because when a claimant has a successful claim, the providers recover on most or all of their artificially inflated bills. And the lawyers and medical providers walk away with larger recoveries than their personal injury clients. 4. Claimants are passed along to medical provider scheme participants without regard to their need for actual medical treatment. Lawyers send claimants with no or negligible injuries caused by the purported underlying accidents to the medical providers with the foreknowledge that the medical providers will recommend and deliver a variety of unnecessary medical treatments including surgery, and will thereafter submit an artificially inflated bill and/or recommend future surgeries with artificially inflated estimated fees. As such, it is routine for the medical providers to produce fraudulent documents diagnosing non-existent or exaggerated injuries, falsely linking these injuries causally to the accidents and then proposing and performing costly, invasive, and/or unnecessary surgeries, together with the artificially inflated resulting bills. The attorneys use these fraudulent documents and unnecessary treatments as a basis for fraudulent lawsuits and/or claims for damages. Because of such overtreatment and inflated liens held on the recovery by the various medical providers involved, the claimants themselves commonly walk away with relatively minimal recovery compared to the fees that the lawyers and medical providers receive. Rideshare companies such as Uber are prime targets of this fraud scheme because of their $1 million insurance policy limits, which are higher than those of almost every other vehicle on California roads. The perpetrators of the fraud make no secret of targeting Uber because of these high policy limits. While rideshare companies are prime targets, they are by no means the only victims of this scheme. The examples described below are only a partial illustration of the extent of the scheme. It extends well beyond the defendants described herein. 8. A key repeat participant in this fraud is defendant Greg, a spinal surgeon who owns and controls GSK Spine, an orthopedics practice, working with personal injury coordinators at defendant Radiance Surgery Center, a surgery center which specializes in treating patients with pending personal injury lawsuits and which also does business as Sherman Oaks Surgery Center. Khounganian accepts referrals from lawyers who have cases against Uber, with the understanding that he will perform specific acts to increase the value of their lawsuits and/or claims. Khounganian produces fraudulent documents diagnosing these lawyers' clients with specific injuries, relating those injuries to minor accidents, and recommending costly, invasive, and/or unnecessary surgeries. In such cases, instead of billing his patient's health insurance, Khounganian works on a lien basis, signing agreements with his patients so that he gets a substantial cut of their eventual lawsuit recovery. Both he and Radiance Surgery Center conceal their secret side agreements with the referring lawyers to discount such liens, to increase his desirability as a referral source for the lawyers. Khounganian produces fraudulent records of medical necessity and/or causation that he transmits to the lawyers for the purposes of artificially inflating claimed amounts. These lawyers include defendants Igor Fradkin and his law firm, Downtown LA Law Group, as well as Jacob Emrani and his law firm, law offices of Jacob Khounganian, Emrani Fradkin, and their respective practices are engaged in a racketeering scheme that is actively harming UBA. The unnecessary medical treatments, fraudulent medical records, and fraudulent and misleading medical bills allowed Emrani Fradkin and their law firms to attempt to induce significantly larger settlement payments out of Uber and personal injury lawsuits. Uber has incurred substantial expenses defending against these false and inflated claims. Uber believes that Khounganian's actions have fraudulently tainted at least 9 cases against Uber and dozens more against other personal injury defendants. Because this fraud spans numerous cases, including those where Uber has not been named as a party and involves out-of-court corrupt activity. The usual tools of sanctions motions, affirmative defenses, or counterclaims are ill-suited to remediate the fraud. Through the federal RICO statute, Congress gave federal courts the power to address schemes like these that thwart state remedies by specifically authorizing broad equitable powers to terminate the conduct and ensure it will not reoccur. In addition to recovery of the serious injury it has suffered, Uber respectfully seeks both monetary and equitable relief from the court as authorized by the RICO statute to prevent such conduct going forward.